So the next argument is Stephen Pascal and Chris Gates versus the City of Pittsburgh Zoning Board and Northside Leadership Conference. Representing appellants is Ms. Patricia L. McGrail. Representing Northside Leadership is Mr. Stuart C. Gall, Jr.
Good afternoon, everyone.
Afternoon.
Before the court are two issues related to a decision issued by the Pittsburgh Zoning Board of Adjustment granting variances and exceptions to the Northside Leadership Council, allowing it to develop several parcels of its property located on the city of Pittsburgh's north side. Appellants are citizens, and they appeared at the public hearing on the Northside Leadership's applications and opposed the request for variance and exceptions. There are three members of the Zoning Board of Adjustment, and they presided at the hearing. One member, it was later determined, was also on the Northside Leadership's Board of Directors at the time of the hearing and the decision on the Northside Leadership Board's applications. At the conclusion of the hearing, parties were directed to submit additional findings of facts and conclusions of law for additional 2 weeks after the transcript was available. After additional findings were submitted, the Northside agreed to several continuances for the zoning board to issue its decision. The board granted Northside's applications on August 23, 2018. The board's decision was sustained on appeal by the trial court and the Commonwealth Court. Appellants, who are the citizens, challenged the board's decision, argued the decision is void based upon a conflict of interest, and that one of the panel members of the Zoning Board of Adjustment also sat on the Northside Leadership Council, simultaneously sat on the Northside Leadership Council's Board of Directors. Appellants also argued the zoning hearing board's decision was untimely, where it was issued more than 45 days from the date the hearing was held. We have two issues before us. Ms. McGow, feel free to proceed. You have 2 minutes to explain. I hope uninterrupted, and then we'll start asking you questions.
Okay, very good. Thank you, Your Honor. Again, I am Patricia McGrail, representing Stephen Pascal and Chris Gates, appellants in this matter. The appellants are respectfully requesting that this court reverse the decision of the Commonwealth Court and, of course, the trial court and the ZBA as it relates to the decision made with regard to the application of the Northside Leadership Conference, which included an application for both variance and special exception. Our request is based on two matters. One is the failure of the ZBA to render the decision within 45 days of the public hearing. At the time the ZBA did render its decision, 98 days had passed from the date of the public hearing. The second basis for our appeal is the fact that a member of the board of directors of the Aplt, that is the Northside Leadership Conference, also served as a board member of the Zoning Board of Adjustment of the City of Pittsburgh, and in fact was one of 3 zoning board members who sat in on the public hearing and participated in the decision-making process and did in fact sign the ultimate decision that was issued on August 23rd, 2018.
Ms. McGrail, it's Justice Todd. Just a quick clarification. If we rule in your favor on the conflict of interest issue, do we still need to even reach the 45-day issue, in your view?
Your Honor, in my view, you do not. Relying on the Horn case, and I won't necessarily get into my argument, but the court in Horn found that where there is an appearance of impropriety or possible prejudice, there is a denial of due process, and I believe that would create a requirement to reverse the decision of the court below.
Thank you.
Based upon that, Ms. McGraw, why don't you, because I was of the same view as Justice Todd, so why don't you argue your conflict of interest issue first and make sure we get that fully vetted, because I think that before we get into the issue of the timeliness, and I'm not sure we would have granted on that alone, we're going to have to explore this conflict of interest and resolve it. And I'll just say, since I have the floor, you did not cite the Williams case from the United States Supreme Court, which involved our court. It involved Chief Justice Castile, who had previously been the District Attorney of Philadelphia County, and participated in a decision regarding the death penalty, seeking the death penalty, and then subsequently sat on our court. And of course, we do automatic review of all death penalty cases, and he was involved in that. The U.S. Supreme Court called that structural error, much like Gideon, and said it's a deprivation of due process. And I only mention that because going into oral argument, I think that case may be precedential in this case.
Chief Justice Baer, that case was addressed in the briefs. Maybe I'm now not in either.
No, not at all.
Because that is a case that, while we may not, it impacted us, while we may not agree with the holdings, that is, the precedent from the U.S. Supreme Court, a very similar situation.
And I would agree that in fact it is similar. But just to review, the public hearing was held on May 17, 2018. That hearing was held in front of the Zoning Board of Adjustment of the City of Pittsburgh that was comprised of 3 members. And LaShawn Burton Falk, and I will refer to her as Ms. Falk going forward, did indeed sit in on the public hearing and heard the presentation by the Aplts, as well as heard the objections of the interested parties that were present at the time of the hearing. She participated, as far as the record shows, all of the way through this process. Many times an alternate is available for appointment when there is a conflict. That did not appear here at the public hearing, nor is it evident in any part of the record that she disclosed that she held a position on the Aplts board. And in fact, when the ultimate decision was entered, and of course, in our opinion, the application had already been deemed denied, but when the board did issue its opinion on August 23rd, 2018, she was a signator to that agreement. And in our view, it is a clear case where there is an appearance of possible prejudice and potentially actual prejudice. The Commonwealth Court, of course, didn't see it that way. And I believe, based on their decision, that was due in part to the fact that there are 3 members of the ZBA. 2 of the 3 would have been sufficient to act to approve this application. But in fact, I believe that Horn versus the Township of Hilltown says otherwise. The holding in that case, as I read it, Your Honor, it indicates that it is not necessary to show actual harm. It is only necessary to show that there was a potential prejudice or a direct conflict. In this case, she had a personal interest as a member of the board of the Northside Leadership Conference in the outcome of the proceedings before the ZBA. There was an appearance of prejudice caused by her position on the Northside Leadership Conference board that was evident or had to, may not have been known to the other board members, the other zoning board members. I'm not aware, nothing is on the record that would indicate that they would have been made aware of the conflict. But nonetheless, we had, following the proceedings, learned that this individual was a member of the board of the Northside Leadership Conference. And we believe that under the Horn case, that is sufficient. The ZBA is a governmental body charged with certain decision-making functions. The parties stipulated there is no factual issue as to whether or not she occupied a seat on the Northside Leadership Conference board. She should have disqualified herself from participating in this action. In fact, the Commonwealth Court indicated in their decision that she should have. The Aplts themselves indicated that she did in fact have a conflict of interest. but that it did not affect, in this instance, the outcome of those proceedings. The appellants believe that it is the appearance of impropriety, the appearance of possible prejudice, which is called into play in this situation, because her conflict of interest may have had an impact on the decision-making process by the other two members of the board. And we have no way of knowing what occurred. Those deliberations were not part of the public record. All we are aware of is what occurred at the May 17th hearing. We're aware that there was a submission of findings of fact and conclusions of law that were due June 12th. We were aware that that a request for a continuance came in July 27th, and that a decision was ultimately made in August of 2018.
Chief Justice Berrigan, I think we understand the point entirely. And so you can move on, but I'd like a alternative member could be appointed to take Ms. Falk's place. I presume 3 new members could be appointed to take the place of this board. Do we vacate and remand for rehearing, which of course is what the United States Supreme Court did do in the Williams case? Do you just win and it's over? What happens?
Your Honor, I believe that a remand would be the fairest result in this case, but I also believe that it would not be a remand to a board that included the 3 individuals who participated in this case. I believe that all 3 zoning board members would need to be new to the case, and the process would have to begin again.
And you're telling us, because it's not in the record, that there is a process within the city by which some city administrator can appoint 3 new people as substitutes.
I believe that is true, Your Honor. I don't have I can't cite you a section of the zoning code, but it is typically true. And what is also very typically true, and those who have been involved in matters before the Commonwealth Court realize most zoning boards have alternates for exactly this purpose. Your Honor, would you like me to move forward with our timeliness argument?
Yeah, succinctly.
Okay. I'll try to be brief. Everyone is already aware of the time frame with regard to these proceedings. There is case law that we think is absolutely applicable to what occurred here. We had a hearing May 17th, 2018. 45 days from that date was July 1st, 2018. As of July 2nd, 2018, pursuant to the terms of the City of Pittsburgh zoning ordinance, there was a deemed denial. The appellee is going to argue, I think, Mr. Gall will argue, that in this case, the 45 days begins to run as of the date of submission of the legal arguments, the conclusions of law, and the findings of fact. I think this court's decision in Wistock versus Lower Mount Bethel Township Zoning Hearing Board resolves that issue squarely in favor of the appellants. It is just as the municipality's planning code provides, so does the City of Pittsburgh zoning code provide, that it is 45 days from the date of the public hearing. The submission of legal arguments do not constitute a continuation of that public hearing. The only exception to this rule is if there is an agreement on the record that grants the ZBA an extension for purposes of rendering a decision, and that is absent in this case. The appellants believe, and again, I won't labor my point, that the Borough of Monroeville versus Foltz case applies in this instance, and in that case, it was on the 46th day that that zoning board issued its decision, and the Commonwealth Court said no, that's you don't get 46 days, you get 45. And you know, I feel like I would be remiss if I didn't just read a quote from the decision in the Humble Oil case, which said, and this is a coercive action, but it says, Without this kind of coercive determination, a board could effectively prevent the erection of needed structures through the simple process of luxurious lolling while spiders of inattention spin webs of indifference over pending public problems. Very artful language, but I think it conveys the point. These deadlines are there for a purpose. In the city of Pittsburgh, it's a deemed denial to stop something from happening that perhaps inattention would have enabled it to go forward. Under the municipality's planning code, it's the exact opposite. It's a deemed approval.
Ms. McGrail, in light of that argument, you and I both may have been in error, because if you prevail on that argument and get a deemed denial, there is no need for a remand.
Your Honor, you're right on that. I think what I struggle with in terms of the conflict issue, if we just decided based on conflict, why couldn't this applicant perhaps tweak the application a bit and go back again with the same project? So, you know, obviously my clients were the objectors. We opposed the project. I would like to take that hard and fast decision that this was a deemed denial and we benefited from it. I just do want to address one other point that is raised by the Aplts. There is not precedent for an interested party rather than an applicant to raise this issue of a deemed denial or a deemed approval. But what the zoning code does in the city of Pittsburgh and under the municipality's planning code, it protects interested parties in the same way that the applicants are protected. And as a result of that, it is our position that an interested party receives the benefit of all of the provisions of the zoning code. If the drafters of the city of Pittsburgh zoning code intended that language to only apply to applicants, it is our position that it would have said so. And it does not, and interestingly, it does not add language to that effect in the municipality's planning code either. Anything else?
I'm sorry, I could not get my computer to unmute. Thank you very much. There being no questions, we'll hear from Mr. Gall.
Stuart Gall. I am here this afternoon on behalf of the Northside Leadership Conference and on behalf of all the appellees in this matter. We are asking this court to affirm the decisions of the Commonwealth Court, the Court of Common Pleas, and the Pittsburgh Zoning Board of Adjustment. As this court is aware, this action arises from a decision approving 5 items of relief, including special exceptions and variances, to allow Northside Leadership to rehabilitate a blighted property on East Ohio Street on the north side of the city of Pittsburgh. And the substance of those grants of relief is not at issue today. The 2 issues on which this court granted review, neither really presents a basis to disturb the judgment below. First, as this court has noted, there is a question of conflict of interest, and on that question, due to the nature of the interests involved, this court should follow its own reasoning in prior cases and the persuasive reasoning of the courts below. On the record here, there's simply no potential for damage to the appellant's interests.
How can you say that, counsel? How can you say that after Williams versus Pennsylvania?
It's tough to say that just in the abstract, but I think, Your Honor, if you look at, and as the Chief Justice has described the case, if you look at the interests that are involved here, that is a death penalty case, as it's been described. In this case, the interests are greatly reduced from that. And
The due process clause is different for death penalty cases than it is for proceedings of this type. I thought there was only one due process clause.
There is a due process clause, but Your Honor, if it's this question of procedural due process, the rule has always been that the due process to which a party is entitled is comparable or at least adjustable based on the nature of the interests that are involved.
So we need a less neutral fact finder in these proceedings than we do in other proceedings. You can have a polluted fact finder in these proceedings.
It's not that you can have a polluted fact finder. It's that if you have a polluted fact finder, you need to look more closely at what the effect of having that fact finder is.
Counsel, since 1975, this court has held in the Horn case, quote unquote, any tribunal permitted by law to try cases and controversies must not only be unbiased, but must avoid even the appearance of it. So following up on Justice Weck's question, since 1975, this court has held that the appearance of bias is enough even without a finding of prejudice. How do you overcome that hurdle in our precedent of long standing?
Well, I look directly to the Horn case, Justice Dougherty, and I note that the Horn case involves a borough solicitor, a municipal solicitor, who was also acting as the presiding officer, ruling on evidence at the hearing, and acting as an advocate for one of the parties. And that's very different from a multi-member situation like this. In fact, what the Horn case says, or what this court said in Horn, is that this case is factually dissimilar from Gardner versus Rapaski, which is the 1969 decision of this court that involved a multi-member panel. And in that case, Gardner did reverse the imposition of sanctions and punishments against the police officer who was involved, but it did so on the basis that the potentially corrupted member of the board cast the deciding vote in a 2-1 decision. That's the same policy that this court has followed, for instance, in the Riverwalk Casino case in 2007. And it's been, and in that case, in Riverwalk, this court looked directly to the Commonwealth Court's decision in Cusick in 2003, and looked at the Borough of Youngsville case from 1982 is also to the same effect. So, with respect, Your Honor, I don't think it's accurate that the potential for any potentially conflicted fact finder necessarily mandates vacation of the case. I think with those cases,
Counsel, correct me if I'm wrong. We're talking Burton Falk voted to grant the NLC's variance exception request, as well as being a member of the board for which requested it. Share with me how that does not distinguish that fact from all the cases you just cited.
I think let's look at the Riverwalk case, Your Honor. And I think the first thing to point out there is that this court chose not to address the question of whether the two potentially conflicted members of the Gaming Control Board were actually conflicted. Instead, this court looked at the Cusick case and said, you know, regardless of whether they're conflicted or not, we're simply going to, there's no potential for them to have made a difference here. And in the absence...
How can you say that after Williams? I mean, at least since Williams, your argument is an absolute non-starter. The Supreme Court of the United States has unequivocally rejected that. It's a black box when you talk about an appellate court. You don't know, you cannot know what goes on between the members of that multi-judge panel. The same thing goes with the ZBA here. You have 3 people, it's a black box, and there's no possible way as a matter of law after Williams for anybody to say, well, we can just disregard Ms. Burton Falk because there were 2 other people there, so it didn't matter. How can you maintain the argument you're making after Williams? I don't understand it.
I think the argument, this is how I can maintain that, Justice Wecht. I think what you do is you look at this court's cases and you essentially say, look, let's do the math. If this person's vote is outcome determinative, then in that situation, yes, we have a per se conflict of interest that's going to require that the case be remanded and redecided. But what this court said in Riverwalk, and particularly in the Borough of Youngsville case from the Commonwealth Court, what the court said in those situations was, look, where the vote isn't going to make a difference, well, we can go beyond that and we can look to see whether there was influence.
Mr. Gall, it's Justice Todd. Sorry for interrupting you.
Sure.
All those arguments and explanations make a lot of sense from a logical perspective, but I have to follow up on Justice Wecht's observation. After the United States Supreme Court decided Pennsylvania v. Williams, I just don't think any of those arguments can be considered. Now, if you have a different view, I'd like to hear that.
Your Honor, the only thing I can offer on that really is just a question of the interests that are involved. And I think I've probably explained myself to the extent I'm going to be able to in response to Justice Weck's questions.
Mr. Gall, you have one final factor, and that is not only the actual conflict, which is glaring, but the perception from all parties that are observing this, the interested public. How'd you like to be a litigant that loses a matter in controversy when the applicant's board members sitting on the supposedly neutral tribunal? How could you have a worse perception? Forget about the influence of the vote. I mean, would the city of Pittsburgh want this?
Your Honor, I understand your point. And frankly, in responding to this, we just looked at what we relied upon is the decisions that the court has reached in the past and that the Commonwealth Court has reached in the past. Mr. Cusick, for instance, was probably not thrilled that he was not able to keep his helicopter on his property as a result of what he saw as a conflict, and that issue remained unresolved.
Thank you.
So,
Yeah, the second question, I don't have any other. I guess you move on to the 45 days. The code seems pretty clear. Is there something I'm not reading in the code? It said you have 45 days to make a decision.
well, what happens with the code is the code also says that the board is free to write its own rules. And what's happened in this situation is that the board has expressly adopted and published a policy by which the 45 days run from the findings.
We were statutory enactment
The code?
by their own internal regulations.
Yeah, same question.
Your Honor, if you look at this court's decision in Broussard, that case also involved the city the city of Pittsburgh zoning code, and it involved a question of whether for a special exception, a particular type of lease had to be recorded as a precedent to the courts to the ZBA's granting the special exception. What this court said there is that it was entitled to that this court and the Pennsylvania courts should defer to reasonable interpretations of the regulation. Now, in a situation
They
like
could say
this,
by regulation that statute says we have 45 days, but we've decided by regulation to make that 90 days. Is that correct?
I don't think that they said that, Your Honor, and I think that by adopting the policy that they adopted here, they avoided a significant constitutional problem running the other way. There's a clear entitlement to use property in a permissible manner, and a construction of the ordinance that allowed the ZBA to deny an application or deny what after Valley View is a lawful use of property simply by essentially a pocket veto would raise serious constitutional questions about the denial of due process and rights there.
Any further
Well,
questions at all?
Can I just follow up briefly on Justice Saylor's question? I know you're in a difficult position because you're here defending the conference, but also the city that's not your client. It's interesting the city didn't show up to argue, but there's no reason why Northside Conference couldn't have said to the ZBA, Madam Chair, we'd like you to continue the hearing, or that presumably the ZBA on its own, sua sponte, might have said, I don't think we're done here. We're going to continue this either sine die or till next week or what have you. That's not what happened. Here, the hearing ended and the ZBA invited proposed findings and conclusions. Aren't those different things? I mean, the hearing was a done deal, right?
The hearing, the presentation of evidence was largely closed. I would also point out that we submitted a letter from the owner of the offsite parking facility with our findings of fact and conclusions of law. But I understand the concern that you're raising. 2 points to that. One is, again, unlike in WSTIC, there really are published rules here that say we're going to start the clock running at a particular time. And two is, I'm sorry, I've forgotten two. But I guess the point is that at this point, it feels like the appellants are attempting to punish us for having read the board's rules.
Or maybe they just want to hold you to the actual statute under which the rules presumably were promulgated.
Right. And I guess I did remember number two, and I'm sorry about that. This is remember in Wistick, what the court said is, look, you can't construe from the silence, or you can't interpret from the silence an agreement to an extension. But again, this is a very different setting here, because we're not dealing with the sort of potential for a deemed approval that we had in Wistick under the MPC. What we're dealing with here is a deemed denial, so it's actually in our interest to agree to whatever extension of time the city requests. We don't benefit from denying that request. We don't benefit from pushing the board any more than we have to, because we can't control when the board is going to issue its decision. I'd also point out that in its brief, the city pointed out that by starting the clock upon the arrival of the findings of fact, they avoid a situation in which they lose control over certain things. The city doesn't have control over how fast the transcript can be prepared. We could lose this case simply because the court reporter doesn't get his or her act together and get the transcript out to the parties of the board in time. And that is, again, completely contrary to the policy that's underlaying every single one of this board's decisions on deemed approval under the zoning code, or under the MPC. This is really the first case that's involved a deemed denial, but the policy and it leads to a completely different set of policy considerations.
All right. Thank you very much, counsel. Hearing no further questions, if you have a sentence that you'd like to use to conclude, feel free.
Your Honor, again, we don't believe that there's a basis to disturb the decisions below. The due process concerns here are very different from the due process concerns that this court has outlined in Williams. And as to the question of timeliness, we did what the board required us to do. There is no potential detriment to the appellants from waiting for a decision. And we believe that there would be real concerns with our losing on that basis without the boards ever reaching a decision or reaching the merits of the matter. Thank you.
Thank you. We'll take a 5-minute break. We call the next case.
Thanks.
The next argument is the City of Johnstown versus the Workers' Compensation Appeal Board and Michael Sevanick. Representing the City of Johnstown is Mr. Christopher A. Cackline. Representing Sevanick is Mr. Michael G. Dryden.
In this case, Michael Sevanick worked as a firefighter for the City of Johnstown for close to 30 years, retiring in September 2006. In March 2015, he was diagnosed with kidney cancer and missed 8 weeks at a part-time position he had taken after retiring from firefighting. He subsequently sought workers' compensation benefits under the Act under a provision that lists cancer suffered by a firefighter as an occupational disease. A workers' compensation judge awarded Mr. Sevanick more than $4,000 for his 8-week disability, and the Workers' Compensation Appeal Board and Commonwealth Court both affirmed. The issue before this court is whether the Workers' Compensation Act's 300-week rule found at Section 301C2 is a statute of limitation or statute of repose, which would bar Mr. Sevanick's claim, or conversely eliminates the statutory presumption that firefighting caused his cancer while allowing his claim to proceed on the merits. Mr. Cackline, feel free to introduce yourself and proceed.
Good afternoon. May it please the court. My name is Christopher Cackline. I'm representing the City of Johnstown in this appeal. The matter before the court is one of simple statutory application and stare decisis. This court is charged with applying relevant statutory provisions in a manner that's consistent with the court's past cases. Here, that could not be closer to the remedy that appellant is asking of the court. Appellant is asking the court to reverse the Commonwealth Court's decision because the Commonwealth Court failed to apply the clear statutory language of Section 301C2 of the Pennsylvania Workers' Compensation Act to the undisputed facts. As Chief Justice Baer correctly recitated, Mr. Sevanick was a firefighter for the City of Johnstown for 29 distinguished years, retiring September 10th, 2006. 443 weeks later, in 2015, he was diagnosed with kidney cancer, which was a surgical cure. After his surgery, he missed approximately 8 weeks of work from his post-firefighting part-time job at Thomas Honda, thereby establishing disability under the Workers' Compensation Act. Mr. Sevanick filed his claim petition for occupational disease exclusively under Section 108R of the Act, which provides for an enumerated occupational disease for firefighters who develop cancer if certain criteria are met. The issue before the court is whether, as the Act says, 301C2 applies whenever occupational disease is the basis for compensation for disability or death. It, and this court has said, is the entirety of the Workers' Compensation Act shall only apply to disability or death resulting from such disease occurring within 300 weeks after the last date of exposure to the hazard. Here it was determined that the last date of exposure was arguably the date of retirement. That fact is not at issue anymore. So the last date of exposure would be September 10th, 2006.
Could I ask you, counsel, how is it that we're empowered to disregard the word notwithstanding in subsection F?
Justice Wecht, it's because this court has said that no provision of the Act, no section of the Act is relevant when the disease manifests more than 300 weeks after the last date of exposure. In fact, the Act could have said, should Michael Sevanick ever develop cancer, it will be compensable. That provision of the Act would not be applicable because the entirety of the Act does not apply. In Toohey v. AK Steel, this court laid out that Section 301C2 and its 300-week manifestation rule is a jurisdictional boundary of the Act. If a disease manifests outside that 300-week period, the entirety of the Act, and in that case, 303A, the exclusive remedy provision, did not bar Mrs. Toohey from filing a common law action against her husband's employer.
But counsel, that didn't involve Act 46 and the specific treatment of firefighters, did it?
It did not. It was a decision that was decided after Act 46 had passed. Act 46 passed July in 2011, and TUI was decided in November of 2013.
So let me just ask you, because it seems to me you're offering an argument which would have pretty significant implications for us for statutory construction writ large. Like take a hypothetical, say I told my law clerks, I want all the memos that are going to inform me about X, Y, and Z by May 1st. And then I said separately that if there is one that involves firefighters, I'll take it by May 5th. It seems to me, under your reasoning, everybody's bound by May 1, notwithstanding that I said, notwithstanding, any on firefighters can come in by May 5th. So can you elucidate that for us?
Sure. So the term notwithstanding used in the Act is, I'll admit, an interesting use of the word, but given the type of limitations that we're talking about, the difference between the manifestation rule and a portion of 301F that controls whether the presumption will apply to a claim or not, it's not comparing apples and apples. It's apples and oranges. This court said in TUI that any section of the Act, in that case 301A, doesn't apply because the entirety of the Act doesn't apply to this injury. In fact, the court in TUI wrote, "We conclude that claims for occupational disease which manifest outside of the 300-week period prescribed by the Act do not fall within the purview of the Act, and therefore the exclusive remedy provision of 303A doesn't preclude." We could very simply take that exact sentence and substitute in, and therefore the presumption limitations found at section 301F do not apply. This is a gatekeeper to whether the Act applies to a claim. And this court established a bright line rule in TUI that if you fall outside of that 300-week period, doesn't matter what the Act says, what can help you, what can hurt you. It doesn't apply. It's kind of like arguing whether or not a shot in a basketball game was a 2-pointer or a 3-pointer after time has expired. It just doesn't matter.
Counsel, Chief Justice Baird, I can go back and reread TUI again, but we don't get to disregard plain statutory language. And if we really did that in TUI, then we were wrong, and that's a decision we're going to have to correct, although it would surprise me that we would do that. So I want to take you back to Justice Weck's sentence, beginning with notwithstanding, and going in 301F and going down a little bit further in the same sentence, and I know you know this, it says claims filed pursuant to cancer suffered by the firefighter under section 108R, this case, may be made within 600 weeks after the last date of employment. Now, what does that mean, consistent with your argument that after 300 weeks, court loses jurisdiction and the case can't be brought?
Right, and I think this is also a distinction that the Commonwealth Court had a bit of trouble with. In their decision, they talk about the filing limitation and that so long as a claim is filed within 600 weeks, it can proceed. That's a filing limitation that, again, controls application of the presumption and controls whether a claim is timely filed. It doesn't implicate whether the Act applies to that claim. So when you look at the Fargo case, which is a case that counsel and I had together, that is an interesting illustration of the distinction between those two rules. In the 5 cases I cited in my brief, only Fargo was one where the 300-week manifestation rule, that is 300 weeks from last date of employment with exposure to manifestation of disability or death, or of course in a medical-only case, medical costs. Fargo was the only case in which that did not be satisfied. It's out of the 10 years that Act 46 has been in existence, Fargo and Sevanick were the only cases that were brought that violate this 300-week rule. And in that case,
Let me interrupt you just because I don't want to get off this point. I'm looking at the plain language of the statute. We don't usually get the benefit of plain language. We're always trying to figure out what the legislature intended.
sure.
And it says, and again, I don't mean to be repetitive, but it says claims filed pursuant to cancer suffered by a firefighter under Section 108R. So that is certainly a workers' compensation action. That is certainly the case before us, may be made within 600 weeks. So this, again, I'm lost, and I want you to enlighten me. You're saying after 300 weeks, I understand you can file a tort action under your theory, but you're saying under 300 weeks, you can't file a comp action. And it seems to me this language is saying just as clear as anything I get to see in my job that you can.
Sure. So I think the distinction is that if a person is, let's say, disabled 100 weeks after they retire as a firefighter, they now have a colorable workers' compensation claim. The Act applies to them according to 301c2 and 2e. From there, there's a separate filing limitation. A claim must be made or a claim must be filed within 300 weeks of that same last date of exposure if the presumption shall apply. If they file from 301 weeks to 600 weeks, they can make a claim, but the presumption does not apply. But it's all predicated upon step one, which is, did their disease manifest within the first 300 weeks after the date of last exposure? It has nothing to do with filing, giving notice, telling the employer that I have cancer. It's a simple calculation of last date of exposure to some substantial manifestation of the disease. And of course, this court has said that that's not just for disability or death. That can also apply in a medical-only situation where some manifestation of the disease is present. But it has nothing to do with something the claimant has to do. It's not a filing limitation. It's not a statute of limitations. It's a statute of repose, according to the Commonwealth Court, that requires a filing deadline. But none of that matters if the disease does not first manifest within the first 300 weeks.
But sir, if the disease manifests within the first 300 weeks, you get the presumption, correct?
You may, if you file within that same 300 weeks. So the C2...
Again, and I'm going to quit and I'll just have to go study the case. But how do you file after the 300 weeks under your reading of the statute? You keep telling us the 300 week is, be it a statute of repose or limitations, I haven't thought that through, but precludes any subsequent filing.
It's not, so that the end date for the two issues are different. 301c2, the end date is, were you disabled from cancer? For 301f, this 600 week rule, the statute of repose, the filing limitation, it ends with the making of a claim. And there's an argument as to what that means, but the more fundamental issue, the first step that has to get passed, in any case, you look at the last date of employment with exposure, call it December 31st, 1999. You then have 5.5 years or 300 weeks to be diagnosed with a cancer. If you meet that, you have this additional filing burden, which controls the presumption.
If that was the case, counsel, then the General Assembly would not have used this notwithstanding clause. See, your argument might hold water, it seems to me, if all of that language before the part that says claims filed pursuant to cancer suffered, etc., by the firefighter was cut out. But we're not free to delete or disregard words the General Assembly chose. So with this language, doesn't it seem unavoidable that regardless of whether you have a manifestation approach or you have a petition filing approach, and the lawmakers are free to choose between those, the replacement method applies by virtue of their choice of the word notwithstanding. I'm still hung up on how you seem to be dumping the word notwithstanding.
Well, I'll first go back to the original argument, which is this court in 2E told us that that's what we have to do. It doesn't matter what any other section of the Act says. It doesn't apply to Mr. Sevanick because his disease did not manifest in disability or death within that 300-week period. So again, it could say, Mr. Sevanick, your claim is compensable, but that would never apply to him because his disease was too far attenuated from his service as a firefighter. But additionally, if looking at Act 46, the bill that became Act 46, which was attached as an addendum, it was House Bill 797 of 2011. There are other changes that the General Assembly made to Section 301C2. It contemplated all the ramifications of these new statutory provisions and corrected contradictions. It saw the contradictions in itself. It did not see the notwithstanding language as a contradiction. It said, we understand that the manifestation rule requires the disease to be diagnosed within 300 weeks. We see that, we know it, we understand it. But we're going to impose a filing limitation on these claims. We want to give firefighters more time to file. So we're going to allow them to file on a longer tail, notwithstanding the fact that the disease still has to occur within 300 weeks from their last date of exposure. And in fact, you can see two changes in House Bill 797 that show that this is accurate. First, in C1, and I've put this in my brief, a person's prior physical condition is irrelevant in a workers' compensation claim. You have an eggshell claimant. You take them as they come. If they have degenerative disc disease and they have a slip and fall, it doesn't matter. You buy their previous physical condition by hiring them, except for Act 46 claims. 301F says their prior history is relevant. They cannot come to the job with cancer. So you have to prove that they didn't have cancer prior to joining the fire service. That creates a conflict. 301F says prior physical condition is irrelevant. Noting the contradiction, the General Assembly amended C1 and provided a section that says, except as provided under Section F of this subsection, previous physical condition is irrelevant. They understood the contradiction, they fixed it. They did the same thing in C2. It added a section to C2 which allowed 108R claims, and it's not terribly relevant to this case, but the employer liable for compensation will be different in an Act 46 case than others. So the General Assembly looked at contradictions, they fixed them, and they didn't think notwithstanding language created a contradiction, which I don't believe it does either. A firefighter can be diagnosed or disabled from a disease within 300 weeks of his last date of exposure. That gets him or her into the Workers' Compensation Act. If they want to file a claim, they have a 300-week, 600-week filing limitation for which there's implications of application of the presumption. They also have a Section 315 statute of limitations, which is filing a claim within 3 years from the date they know they have a colorable claim, essentially. They know or should have known that their disease was related to their job. So these three sections very easily coexist, and they serve the same purpose that 301C2 has always served, which is a protection against stale claims, stale diseases. 5.5 years after retirement from a job is a lot of time to have exposure to other substances that might cause your cancer. It's also a long time for an employer to not keep records that would be absolutely relevant to litigation. So the same construct that made 301C2 proper still applies here. And going back to the Tui versus AK Steel, because I think that really forecloses the issue. I think this court has decided this issue already. The Commonwealth Court has said that the 300-600 week rule of Section 301F, that is the controlling of the presumption, the filing limitation, is a statute of repose. A claimant has to do something to avail themselves of the act. This court has said that 301C2, this manifestation rule, is not a statute of repose. That was argued to the court in Tui, and Justice Todd wrote that the court did not accept the contention that C2 was a statute of repose. It was not eliminating recovery, it was eliminating application of the act to a claim that was based on a disease that was attenuated from the last date of exposure. And therefore, I believe that this court has already decided everything it needs to decide in Tui to decide this case. And stare decisis.
It's Justice Todd.
Yes, Justice.
Would you point out to me the precise language in our Tui opinion that you believe indicates we've already decided this precise issue?
Sure.
Thank you.
And that's right in the opening sentence, opening paragraph, sorry. We conclude that claims for occupational disease, which manifest outside of the 300-week period prescribed by the Act, which would be 301(c)(2), do not fall within the purview of the Act, and therefore the exclusive remedy provision or any other provision of the Act does not apply to the claim in question. So, again, if the Act would have had a specific amendment that said Michael Sevanick's cancer shall be deemed to be work-related, if that exists within the Workers' Compensation Act, it doesn't apply to his case, to his claim. And in fact, the petitioners in that case argued that C2 is just a statute of repose. And then I could see Justice Weck's problem with, we now have two competing statutes of repose. We have one that's saying manifestation within 300 weeks. We have one saying filing within 600 weeks. They would be opposed if they were both statutes of repose. But this court has said that they're not. That C2 is the jurisdictional boundary of the Act, and you can't apply any other section of the Act to a claim that doesn't meet that standard. The final thing that I'll raise was the way that the Commonwealth Court disposed of the case, and that was by review of the Haynes case, that's City of Warren v. WCAB Haynes, another case that counsel and I represented the respective parties. Again, in that case, that was a retroactivity case, whether it was constitutional to retroactively revive a right that was otherwise eliminated under the Act. I don't think that has the bearing that the Commonwealth Court thought it did. I think, again, that this case is dominated by the court's opinion in TUI, and that no section of the Act can apply to a claim for occupational disease if that disease manifests greater than 300 weeks after the last date of exposure. The only other thing I'll address is something that Apelli addressed about making this a more limited act for firefighters. I don't believe that's true. As I stated, in the 10 years that Act 46 has been an avenue for firefighters to seek compensation, this is one of two cases out of probably close to 500 that have run up against a 300-week manifestation rule problem. I don't see it as a significant impact to firefighters making claims for cancer. In fact, most of the claims that we have are from firefighters who were diagnosed while still in service to the fire companies that they give service to. And that concludes my argument. If there are any other questions, I would be happy to address them. I understand that it's confusing by the virtue of the fact that both rules have 300 weeks in them, and it's difficult to separate out how they should play together. But it's appellant's contention that they do play well together, that they complement each other, and they serve the purposes of the Act by creating a presumption for firefighters only within the same construct that any other employee with any other occupational disease would have to satisfy.
Counsel, it's Justice Donahue.
Yes,
if we had never decided TUI, would you be making the same argument before us today?
No.
Okay, so then I guess what also is implicit in your argument is that the legislature cannot be saying that despite our interpretation of TUI, 302 does not apply to a firefighter, because that seems to be what, reading the notwithstanding language and taking into account that we have interpreted this particular provision of the Act in TUI, I think that we have to conclude, which is what I think your opposing counsel is argument, that it's not only notwithstanding the language of that section, it's notwithstanding what we said that section meant in TUI as it applied to other occupational diseases.
Well, I don't think that can be true, because TUI was decided 2.5 years after Act 46 was passed through the legislature and became law. So certainly the General Assembly could not have ever anticipated that the TUI decision would be decided the way it had been in 2000.
But counsel, they were always treating firefighters differently.
Well, that's absolutely true. I noted in my brief that firefighters are the only occupation that have enumerated occupational diseases only for themselves, barring others. And in fact, coal workers' pneumoconiosis is not even limited to coal workers. Firefighters do have special treatment, but in this case, the special treatment is limited to application of the act. It has to be a workers' compensation.
Only because of the way you are interpreting the effect of our decision in TUI.
Yes, I think it's from the direct language of the TUI opinion that no section of the act can apply if the disease manifests outside of the 300-week rule. So it's not just the TUI opinion. I would say that 301c2 provides the standard framework that's been in place since the Occupational Disease Act was absorbed into the Workers' Compensation Act. I would say that the legislature understood that that was the limitation. They understood that the disease had to manifest within 300 weeks, but they wanted to give, again, firefighters special treatment and give them a longer time to file. So they took it down from 300 weeks of manifestation, and they gave an additional 300 weeks to file a claim.
Okay, thank you.
But again, it all comes back to the very first step. Does the Workers' Compensation Act apply? If yes, let's look to 108R. Let's look to 301F. But if it doesn't, those sections are irrelevant.
Thank you very much.
Thank you.
Dryden?
May it please the court, my name is Michael Dryden. I represent the respondent, Michael Sevanick. Mr. Sevanick is as you indicated, Judge Baer, a retired Johnstown firefighter. He successfully claimed a small period of wage loss benefits, but also more importantly, medical coverage from the Pennsylvania Workers' Compensation Act for kidney cancer, pursuant to sections 108R and 301F of the Act, also known as the Act 46 Firefighter Cancer Amendments. He made that successful claim without the rebuttable presumption, by the way, available under the Act. Today, the statutory construction issue raised by counsel and appellant does not actually challenge Mr. Sevanick's fire service exposures to Group 1 carcinogens as a firefighter or medical evidence relating his cancer to his firefighting career. Instead, appellant suggests an interpretation of Section 301F that would require Mr. Sevanick or firefighters like him to establish both the 300-week manifestation period found in Section 301C2 and the limitations filing period provided by the General Assembly specific for Section 108R in 301F. This interpretation actually challenges Mr. Sevanick's ability to ever make this claim and challenges the ability of firefighters like Mr. Sevanick ever to make this claim, in spite of the fact that when he files his petition, subsequent to the passage of the Act 46 amendments in July of 2011, he is a firefighter, and counsel had the exact number of weeks, I think it was 433 weeks, since his last service, near 30 years of distinguished service and honorable service to the city of Johnstown ended. So he fits within the four corners of Section 108R and 301F of the firefighter cancer presumption provision. And we're now being asked to look at the Section 301C2, 300-week manifestation period, as an additional limitation on a veteran firefighter diagnosed with a latent disease, obviously cancer, and try to limit their ability to make a claim. So the outcome of this appeal, and indeed I think this court's interpretation of Section 301F, controls not just whether Mr. Sevanick will continue to have medical coverage through the appellant for his kidney cancer, but more broadly controls how many of the 4,000 men and women who make up the current paid and volunteer fire service, as well as retired firefighters and their dependents when we're looking at fatal claims, how many of them will have full access, the full access intended by the General Assembly when it passed Section 301F. Council's effort here is to limit that access. The appellant's effort is to limit that access by opposing a double limitations period instead of just the limitations period that is plainly stated in the statute. Respondent submits that the interpretation of Section 301F provided by the Commonwealth Court in this case and provided by the Pennsylvania Workers' Compensation Appeal Board must not be disturbed, as it correctly effectuates the intention of the General Assembly, as this court has routinely expressed is the intent of judicial interpretation of statutory language. The correctness of the Commonwealth Court's interpretation of 301F as the sole limitations period applicable to firefighter cancer claims under Section 108R is, as indicated by several of the justices, Justice Weck, Justice Baer, that questioned counsel, by the plain language of the statute. You know, it is also, I think, evident in the General Assembly's decision to even come up with a Section 301F
Mr.
limitation.
Dryden,
Yes.
Chief Justice Baer, two questions, and I think we can move along. First question is just how do you see the 300, 600 weeks working? Is the dichotomy that if you file within 300 weeks, you get a presumption, and if you file between 300 and 600 weeks, your claim goes forward where you don't get a presumption, or is it something else? That's question one. Then question two, which I think is the probably decisive here, is why is opposing counsel wrong that TUI controls everything?
The first part, Judge, I think for my read of the plain language of the statute, consistent with the board, consistent with a workers' compensation judge with decades of experience, a judge manager from Pennsylvania and the Commonwealth Court, is that the word notwithstanding simply can't be ignored. The word notwithstanding, which we've, in our brief, gone through Black's Law Dictionary and Cambridge Dictionary and sussed out that that means without consideration of or not needing to allow for. When you replace notwithstanding with without consideration of or not needing to allow for, then plainly Section 301F says that that section of the law has been, Section 301C has been replaced by Section 301F. So to your specific question, the way we see the limitations period working for a firefighter is as laid out by the Commonwealth Court in Caffey, and in this case, the end of the firefighter's career, the end of their exposure to the hazards of firefighting, the carcinogenic hazards of firefighting in smoke, soot, and diesel emissions. From that point, they have 600 weeks to file a petition to pursue benefits for cancer under Section 108R of the Act. If that petition is filed within 300 weeks, they make that claim with the presumption. If it's filed 300 weeks and 1 day, they have to make the case without the presumption. If it's filed 600 weeks and 1 day, they cannot file their petition. And according to this court's seminal decision, one of my favorite decisions, TUI, then after 600 weeks, we have our right to go to a jury and talk about the negligence of, not having a diesel fuel capture system in a firehouse or not enforcing standard operating procedures regarding wearing a mask at a fire. We get to go do that. But the place where the line is drawn is at 600 weeks from the end of the firefighter's service. There to me is nothing in the TUI decision that addresses this. As I had indicated earlier, TUI, I think, is one of the seminal decisions of the Supreme Court for people like me who spend a lifetime representing workers, and particularly injured workers and union workers. That, in TUI, the issue was the scope and extent of the Section 303A exclusivity provision. In TUI, the court was faced with a mesothelioma case, which is a 108L listed occupational disease. As I'm sure the court's aware, in Pennsylvania, occupational disease is a term of art. It refers only to the diseases listed in Section 108. 108R, the firefighter cancer provision, is the most recent disease listed, but 108L was at issue in TUI. That dealt with asbestos exposure. The plaintiff in TUI had been diagnosed with mesothelioma after a career that exposed him to asbestos, but the disease didn't manifest itself until more than 20 years later. And the question was, did the employer get a holiday, get protection from the exclusivity provision of the Act in TUI, because the fact that you could make an asbestos-related disease claim, but that particular plaintiff claimant couldn't do it because of the time that had passed. And this court examined all of that, all of the statutory sections that applied to that case, and made the correct statement with regard to 108L. In fact, with regard to every disease except 108R that's listed in Section 108. I'll completely admit Section 301C2's manifestation period applies to every disease from A to Q. The unique fact that we have in this case is that the legislature took the time to create a limitations period, took the time to select the word notwithstanding, which we've all agreed means ignore Section 301C2. And then after taking the time to do those two things, laid out the statutory limitations period applicable to a firefighter cancer claim in plain language. That issue was not ever brought up into it. Even though the case happened about 16 months after the law was passed, there were no appellate cases, even in the pipeline, regarding the firefighter cancer presumption law. I know that because of these cases, counsel and I probably have 90% of them. Every
Can I ask you about two of those cases?
One of ours. Yes.
Assuming you've answered the chief's question, I have one question. Two of those cases are Fargo and Szymanski, and you mentioned those in your brief and discussed them briefly, but you don't call for them to be overruled. In order for us to agree with you, do we need to overrule those two Commonwealth Court cases? Don't they both stand for the proposition that the firefighter has to satisfy both of these 300-week and 600-week provisions rather than just the 600-week one?
First, Justice, I filed petitions for allowance appeal of every one of those cases because there are elements to those decisions that I disagree with. But I went to Catholic school, so if you hit me over the head enough, I learned. So after all my petitions for allowances of appeal were denied, I stopped fussing over the issues that I have with what was done in those cases. But I don't think you have to overrule them because what counsel cites to in those cases is really dicta. The Fargo decision was decided purely on Section 301F. That in that case, firefighter Fargo had last served in 2001. We filed our petition in 2014. I then and now, despite my failures with petitions for allowance of appeal, believe that we should have access to the discovery rule with Section 301F, especially when the Commonwealth Court is going to bring Section 301C2 to the dance for diseases that happened prior to, or diseases that were diagnosed, cancers that were diagnosed before Act 46 became law. They applied in that case, they referenced applying both 301C2 and 301F, but didn't give us the discovery rule. I found that problematic. But the holding of the case, the way it was disposed of was by saying, pursuant solely to Section 301F, the petition wasn't filed in 600 weeks and you're out in Fargo. So there is no holding in Fargo that 301C2, the requirement of 301C2's 300-week manifestation period coupled with 301F caused him to be out. I believe that the same is true in the Szymanski case, that in the end with Szymanski, the court looked at when we filed our petition and remanded the case saying that we did not have the presumption. And then when we went back in front of the judge did not find our evidence sufficient enough to overcome the full burden of proof in a non-presumption cancer claim. So the claim was denied. But I don't believe in either case was the holding that a firefighter had to overcome both the 301C2 and 301F limitations period. I think the Commonwealth Court clarified that in the Caffey case. When we look at Caffey, and footnote 6 of Caffey states, nevertheless, as noted above, Act 46 created a new time limitation which applies only to firefighter cancer claims, and they cite Haynes because that language comes out of Haynes. I agree with counsel that the facts of Haynes are different, but that is something that you can cite that case for. The next sentence is important in Caffey. The court stated, instead of the 300 weeks that applies to all other occupational diseases, a claim filed under new Section 108R defining cancer suffered by a firefighter may be made within 600 weeks after the last date of exposure to the hazards of the disease. So I think that language is completely consistent with what the Commonwealth Court ultimately did in Michael Sevanick's case. I also think that it's worth noting that the Sevanick case is really the first time where we've had a firefighter before the court who made a claim for a cancer subsequent to the passage of Act 46 and within 600 weeks of his last exposure to the hazards of the job. All of these other cases, as indicated correctly by appellant's counsel, the diagnosis occurred within the 300 or 600 week period, but prior to the passage of Act 46. So the Kospalich and Seitz cases that we have frequently cited in some of these cases, and even in the Sladek case, the court's seminal decision on firefighter cancer in Sladek, the firefighter is entitled to the law as it is at the time he files the petition.
Mr. Chief Justice Barrett, you're obviously both counsel are extraordinarily versed in workers' comp, which I regret. But isn't this case, isn't your position relatively simple? 301F says what it says, and the Rui case,
Tui
case. Thank you. I don't have it in front of me. And the Tui case is factually distinguishable because it doesn't involve firefighting.
That's absolutely true. It's absolutely factually distinguishable. And even with regard to Tui, Justice Baer, Justice Todd's decision in that, as I said, is one of my favorite Supreme Court decisions. And at the end of that decision, the justice notes, thus considerations of the relevant factors set forth in Section 1921, which deals with legislative intent, particularly the remedial purposes of the act and the consequences of both employers and appellants' proposed interpretations, indicates that the legislature did not intend the act to apply to claims for disability or death resulting from an occupational disease which manifests more than 300 weeks after the last occupational exposure. I read that because the legislative intent can't be ignored. The purposes of the firefighter cancer presumption law to provide a better access for benefits for a latent disease can't be ignored. And the humanitarian purposes of the law cannot and should not be ignored.
Counsel, I honestly, you've done a wonderful job. I think we got it. Unless there are any other questions, I'd ask you to sum up.
I will sum up, Judge. And the last thing that I feel compelled to sum up as somebody who represents firefighters from Philadelphia to Erie is to respond to counsel's suggestion that firefighters are taken care of quite nicely by the workers' compensation law. It is true, and he wrote in his reply brief, that firefighters have presumptions for hepatitis C, lung disease, heart disease, and cancer. I think that those presumptions are in there as a clear legislative acknowledgement of the risks that firefighters take. As we sit here, cancer is the #1 killer of firefighters. In the Commonwealth of Pennsylvania, there are roughly 40,000 people that identify as career or volunteer firefighters. When we add in the retirees from the career side, or people who've retired their volunteer service, plus the dependents from those families when we deal with fatal claims, we're talking about a whole lot of Pennsylvanians who've either been married to, been the children of, or actually been people who run into fires, who pull bloody and cut up and damaged bodies out of broken up cars and encounter people's blood and bodily fluids, smoke, soot, diesel.
Mr. Dryden, we got it.
And
I promise you, we understand your case.
And I just wanted, I would feel remiss if I just didn't respond, because I think those things are in there because they're deserved. That's where I'll end. Thank you very much.
Thank you very much. We'll take a 5-minute break and do the last case.
Take care now. Have a good day, everyone.
So the next argument is Apartment Association of Metropolitan Pittsburgh versus the City of Pittsburgh. Representing the city is Miss Wendy Kobe. Representing the Apartment Association is Mr. William L. Stang.
Apologize for the technical difficulties. As always, our staff did a great job. Mr. Stang is going to argue by cell phone, although I think his video works, but it doesn't work in conjunction with audio. So it's going to be up on video, but arguing by cell phone, and hopefully we'll all hear him well. In December 2015, the City of Pittsburgh enacted an ordinance that made it unlawful to deny a person access to housing based upon his or her source of income, a term which includes the federal Section 8 Housing Choice Voucher Program. Both the trial court and the Commonwealth Court concluded that, in accord with the business exclusion provision of the Home Rule Charter and Optional Plans Law, the city lacked the authority to enact this ordinance. The court granted allowance of appeal to examine whether the Commonwealth Court's decision comports with our recently issued opinion in Pennsylvania Restaurant and Lodging Association versus the City of Pittsburgh. Ms. Kobe, feel free to introduce yourself and proceed.
Thank you. May it please the court, Wendy Kobe for the City of Pittsburgh. As Chief Justice Behr stated, the city enacted this ordinance in December of 2015. Earlier in the year, the U.S. Supreme Court had determined that disparate impact was a valid theory for enforcement of rights under the Pennsylvania Human Relations Act. To identify a class, the City of Pittsburgh identified the class of holders of housing choice visa programs. As indicated in the reproduced record in this case, the city determined at that time that 41% of the housing choice voucher holders were not able to exercise this right in the City of Pittsburgh. In accordance with its obligations to the residents of the city enacted this ordinance. Through the litigation, this court has altered the standard by which it interprets the business exclusion prohibition on actions by home rule municipalities. When this court remanded the case to Commonwealth Court didn't apply the correct standard. This point is articulated in the city's brief. And so the city is relying on the authority that it has as its own police power and the police powers that are granted to it through the Pennsylvania Human Relations Act. As this court has recognized, general police powers do support local action in furtherance of a broad general welfare pronouncement like the source of income.
In that case, didn't we specifically say that police power alone was not enough?
You did say police power alone was not enough. However, the source of income relies on the unique situation of being able to enact an anti-discrimination provision. The state statute of general applicability, the Pennsylvania Human Relations Act, allows for local municipalities, regardless of municipal status, to have a local commission. It has been interpreted by the State Human Relations Commission to authorize municipalities to identify classes that need this kind of anti-discrimination protection based on the local concerns. And that is independent of status as home rule or not home rule.
And the fact that the PHRA says nothing about source of income is of no moment for us?
It should be of no moment to this court. The Human Relations Act has been interpreted by the State Human Relations Commission to authorize identification of additional classes. This court acknowledged the concept of a state administrative agency having a broad scope of its statutory authority when it's dealing with these kinds of general welfare pronouncements. That's in footnote 19 of the PA restaurant decision. And there have been other cases. Hartman, decided by the Commonwealth Court, made that very clear. This court has not yet had a chance to address that. Indirectly, prior to that, this court did address the concept, although did not explicitly rule upon it, when the city of Philadelphia had a certain local statutory scheme that recognized same-sex partnerships. And the city is simply recognizing a problem that's best addressed at the local level, exercising authority that the appellate courts have told us that we have. And this is consistent with recommendations for how to administer the underlying policy provisions that are addressed at the federal level through the Housing Choice Voucher Program. Since the city enacted this ordinance after the Supreme Court said that disparate impact was a recognizable theory, there have been other municipalities that have done the same. And there have been studies. Something that is not in the record of this case, but that I would ask the court to take notice of, is the Center for Budget and Policy Priorities that has curated reports of efficacy of these kinds of local non-discrimination enforcement proceedings. They have been found effective to enable the policy perspective that the federal government is trying to address. It has been trying to address it since 1968 when this was enacted. The city of Pittsburgh, as referenced in the city's pleadings, continues to face a situation where it has discrepancies in access to affordable housing. The city has issues about disparities along the issues of race. However, when the city did enact this ordinance, it did not expressly rely on a disparate impact theory. It touched upon it, and it is relying on its authority to identify the new class of voucher holders. Voucher holders, by definition of that federal program, are low-income residents. Low-income residents in the city of Pittsburgh we would expect them to be African American based on the statistics that have been reviewed extensively about the demographics of the city, looking closely at what the city's economic issues are and policy priorities that the city needs to address.
Ms. Kobe,
Counsel, I'm sorry.
I'm sorry, Justice Doherty, you have a question? Go right ahead.
Yes. Counsel, my concern is what you're arguing to us is that what is statutorily imposed. I have a concern here that the city's position that it has its police powers to impose an obligation going against a fundamental constitutional right to have property. Whereas the Philadelphia ordinance was to end discrimination and permit same-sex couples the ability to have a contractual agreement with the insurance company is completely different than your suggestion that a government has the right to impose restrictions or impose obligations on a fundamental right of property ownership. And it's going to be probably challenged down the line as equal protection for those who own property but don't choose to rent. So share with me, why are we forfeiting or why are we predicting a constitutional challenge if we were to agree with you? How are we going to sync that up?
Quite simply, this is not a taking, as that is understood by state law, and we would expect that it would not found to be a taking under federal law. Under state law, what is happening is not anything that even sounds like eminent domain. The city is not exercising any eminent domain powers. It is not taking any property.
Counsel, let's take that, let's parse that. So if the homeowner chooses not to meet the requirements imposed by Section 8, what is the next step for the city? To take the homeowner to court for sanction? And if that's true, because that would be the alternative to impose the guidelines, How is that not a taking when you're taking an individual's right, constitutional fundamental right to property?
Well, people do have a fundamental constitutional right when they own property, but not necessarily to operate as landlords. By being a landlord, someone's operating a business. Landlords are already prohibited from conducting their rental businesses in a discriminatory fashion.
So if we follow the argument to the logical extreme, the mayor of Pittsburgh should open up the municipal building on Grand Street to house people and accept Section 8 vouchers?
Well, there would be
If
issues.
we're taking it to this logical extreme.
Well, I think we're making a lot of assumptions between what I said and that as the purported logical extreme, Mr. Justice, because the city-county building is not habitable for residential dwelling. And so we're talking about imposing requirements about something that landlords are already supposed to be doing. Even if we use this court's analysis about the power and authority to regulate businesses that it articulated in its majority opinion in BOMA issued in 2009, all that the city of Pittsburgh is doing is requiring landlords to do what they're already not supposed to do. Landlords are already not supposed to discriminate in provision of fair housing. They already have that obligation. They have that obligation under federal law. They have that obligation under state law. The city of Pittsburgh is merely identifying a class of people that are suffering and not being able to exercise their rights to secure fair housing. And this source of income ordinance is merely identifying it as a class that is subject to enforcement through the procedures of the City Human Relations Commission.
All right, I have one last question for you. Share with me where in the second-class city code it permits your municipality to mandate what is federally voluntarily subjected to.
Nothing in the second-class city code expressly or explicitly allows us to mandate something that is voluntary. However, we have identified an issue which is somewhat unique in the decisional law I was able to identify about housing choice vouchers. Unlike some other decisions which have been cited in the pleadings by the parties that say that it's a burden for landlords to have to comply with that program, which is otherwise voluntary, the facts here are very different. The facts in the city of Pittsburgh are that people who qualify to receive the housing choice vouchers to be able to exercise their right for fair housing are denied the opportunity. 41% of the voucher holders in 2015 were not able to find a landlord that was willing to accept their voucher.
Can I follow up on that briefly, counsel? I in listening to your response to Justice Dougherty, it occurred to me that you still haven't explained to us why, jumping off from the restaurant and lodging case, why this is more like the sick day ordinance than it is like the secure and safe buildings ordinance, which we allowed, right? So with respect to the sick day ordinance, we held in that restaurant case that that was basically okay because it dealt with health, and we said more like a health or safety ordinance that affects business than a statute with its principal focus upon regulating business for its own sake. But we upheld the Secure and Safe Building Act because we upheld the challenge. We struck down that act because it imposed what we call numerous, complex, and continuing obligations upon owners and employees of covered properties. That's a quote. So can you explain to us why your situation isn't far more like the statute we struck down, or rather the ordinance we struck down, the Secure and Safe Buildings Act, rather than the sick days that we allowed?
Mr. Justice Wecht, if I understood the court's reasoning, distinguishing between the underlying sufficiently express authority that enabled the paid sick days ordinance, in contrast to the much more attenuated, my own term, attenuated authority that the city was reaching for to justify the Safe and Secure Buildings Act. I believe the court had reasoned that the core function of the Safe and Secure Business Act was too far removed. It didn't have a sufficient nexus to the statutory authority that the city was relying upon. In contrast to the paid sick days ordinance, where the underlying statutory scheme explicitly enabled regulation at the local level, with a complicated scheme about where the health department would be located, if it would be a county, or if it would be, in the case of the city, a city having access to a health department. That statewide statutory scheme further contemplated regulations and guidelines, and so in this way, the source of income identified as a class of people being discriminated against, the city using the authority that the appellate courts have recognized it has under the Human Relations Act to so define classes when it perceives issues at the local level, and to exercise the authority that the state statute gives to have a local commission which enforces through police powers, local police powers, and the state police powers that are recognized in the statewide enactment to address these issues locally through a commission that can promulgate rules. The city is allowed to exercise legislative power. And so in this way, the statewide statutory scheme contemplates all of this kind of activity and does put our business citizens on notice that it's entirely possible that if they behave in a discriminatory manner, we are authorized as a government with responsibilities to private citizens, to businesses as residents. When you look at our charter, businesses are citizens of the city as well, and balancing all of these interests, looking at the rights of everyone involved with an eye towards the economic health and well-being of the city of Pittsburgh.
Ms. Kobe, and not to interrupt Justice Weck, but if he's finished, I'd like to ask a question. The brief of the Aplt says, and I'd like your response, the effect of including federal housing subsidies from this Section 8 program is that landlords will be forced to participate in the bureaucracy of what is a voluntary federal program and to comply with the numerous burdensome requirements imposed by the program. So that Section 8 program is voluntary, but now it would become, in effect, mandatory. And it goes on to point out some of the consequences, including this: under the source of income ordinance, landlords will be required to seek approval from the housing authority in order to raise rent amounts. This is a contrast to the state of the law prior to the enactment of this ordinance, in which Pittsburgh residential landlords who chose not to participate in the Section 8 program were free to set rent amounts in accordance with their own business judgment and current market positions. So this is pretty onerous when you're imposing those types of requirements on landlords. You're forcing them to participate in a voluntary federal program, and you're forcing them to comply with a federal regime before they can even raise rents.
The rents that are at play in the Housing Choice Voucher Program bear a relationship to market rates. And so it is not terribly onerous. Mandating participation in the Housing Choice Voucher Program is nothing like a different kind of affordable housing scheme that has been implemented in other jurisdictions, rent control. Mandating that landlords ready themselves to receive, to participate in the Housing Choice Voucher Program is actually not as onerous or as far from the.
Why do they call it housing choice? It's not a choice, it's mandatory.
Housing choice is from the perspective of the renter. The underlying policy, if the court needs to hear about that, is to enable opportunities for the holder of the voucher to receive a federally backed subsidy that takes the amount that they can afford to pay in rent and provides the landlord with the balance of the market rate for that rent. The theory being that with this voucher, somebody can move from an area of poverty, which is all that they themselves could afford, to an area of higher opportunity, or as the research describes, lower poverty. And the research also shows that when people are able to exercise their choice with this voucher as a tenant, that the outcomes are better for their children. And looking at many issues about what we understand to be well-being, it is of great social benefit. In this way, the city is clearly exercising its authority to enact something that's appropriate under police powers. Yes.
Chief Justice Behr, the difficulty is you look at the story regarding the city and the parents' patriotic of its residents, which is laudable, I suppose. But the Pennsylvania legislature said in the business exclusion in the Home Rule Charter Law that you can't do that unless it's expressly. And I noticed you used the adverb terribly. It's not terribly onerous. That's sort of lukewarm. But the legislature said expressly provided by statutes. Now, why do you think the legislature has the business exclusion in the Home Rule Charter Law?
I would speculate, Chief Justice Behr, that the reason is so that businesses don't have to work with a complicated, intricate patchwork of potentially conflicting regulations. But exercising our police powers, as we are allowed to do under this.
I think that's correct. You know, how many municipalities are there in Allegheny County? You know, 160 something, I think.
At one point, I believe there were 130, if not 133. That number might be declining.
Okay. So you're a Justice Todd likes my hypos. You're McDonald's and you own your own stores. So you own a store, a restaurant in the city of Pittsburgh, and just across the street, you own another one in I don't care where, in any municipality. And now you have to, as a chief, as Justice Saylor said to you, you have to look at this complex, onerous federal regime in one and not the other. You may even have incentive to close the one in the city well, of course, you're talking about housing. So let's assume it's an apartment consortium that owns a lot of apartment buildings, but it's the same thing. So you're right. I think that's what the legislature wanted to stop. If we accept your argument that either the city's police power or the Human Relations Act can actually let you do this, are there any limits to what the city cannot do? It just seems to me that you're trying to use police power, and I'm not saying it's not laudable, but you're trying to use police power and the Human Relations Act, which has very general provisions, to enact something that the legislature didn't want you to enact. And I think the case is distinguishable from the Restaurant and Lodging Association insofar as there was a statute which had to do with sick leave and sick days, which specifically allowed for the Sick Days Act. And of course, there was those statutes. There was certainly police power, maybe Human Relations Act, that could have dealt with safe and secure buildings, and we deemed it not enough. So I didn't mean to make a speech. My point is that it seems to me that the Pennsylvania legislature, despite the laudable policy that you espouse, doesn't want you to do this, and said so, and used the adverb expressly. And it seems to me that your statutory basis sounds an awful lot more like what failed in safe buildings and safe and secure buildings than it did in sick day.
Chief Justice Behr, the city respectfully disagrees with that categorization of any ordinance which would seek to prohibit discrimination. A statute of statewide application has been interpreted thus far to allow locations to identify classes that require protection from discriminatory conduct. Businesses know that they are not allowed to discriminate.
Wait a minute. Can I follow up on that? Because Justice Behr's question asked you to satisfy the business exclusion, and instead you're going back to your laudable hortatory goal. We have a statute here, and you only get around it if you have something like in the Pennsylvania restaurant and lodging case where you had the disease prevention and control law. You don't have that here. To the contrary, you have the PHRA, which specifically does not say anything about source of income. So you want to add a provision. Once again, it seems like we're talking about something much more like the Secure and Safe Buildings Act than we are the Sick Day Act, which had an anchor. The Sick Day Act had it could anchor itself to the disease prevention law. Here you're trying to anchor yourself to the general police power. We already said that's not enough. Otherwise, the business exclusion wouldn't exist. And then you want to also anchor yourself to the PHRA, which specifically does not protect source of income. Isn't your resort to go back to the General Assembly and ask for this authority for the city of Pittsburgh?
Respectfully, Mr. Justice Weck, the city should not have to. The state statute that prohibits discrimination in housing and for businesses that make housing available to people, it already has an obligation to not discriminate. That same state law has been consistently interpreted the few times it has been on this issue by the appellate courts to allow a location, not home rule, any location, any municipality is allowed to identify a class that is being discriminated against and enact local legal protection for that class against discrimination in such situations as employment and housing.
May I stop you again? And I don't want Justice Weck and I to double team you, so I'm going to say this and shut up. But I don't see any discrimination here. Under your argument, it's discrimination to charge rent. Everybody gets to move into wherever they want to move with as many kids and as many dogs and as many beer cans and as many cigarettes as they want, because anything else is discriminatory. And indeed, charging rent is discriminatory. It's a cute law school argument, but it doesn't fly in the real world.
Mr. Chief Justice, the Housing Choice Voucher Program pays participating landlords market rent. Up to 30 or 40% comes from the tenant. The balance comes through the public housing authority. The landlord receives, with predictable frequency, regular market rate rent for the dwelling inhabited by a tenant in possession of a housing choice voucher.
Ms. Kobe, I know you're probably just about to wrap up, but I wanted to go back briefly to your statement about this not being terribly onerous for the landlords. There's no record here of whether this would be onerous, to what degree it would be onerous, how onerous it would be, because this case is here on summary judgment. We don't have any record one way or the other on that issue, do we?
The record before the court was stipulated facts, which included the city housing authorities' guidelines about this. And so the requirements for a landlord to participate in the housing choice voucher program are included in this record. And when we compare what those requirements are to the requirement of having a habitable dwelling if one is in the business of residential dwellings, it is not terribly onerous. When one looks at the fact that there are some adjustments that need to be made to the lease, some terms need to be explicit in the lease that are not required by the Landlord-Tenant Act. There is nothing in the Landlord-Tenant Act that prohibits, for the sake of preventing discrimination, adding these few requirements. And these are not overly onerous. The level of additional obligation that is being imposed for the sake of avoiding discriminatory conduct already made illegal at the state level is authorized.
Is that just your perspective, though, or does that reflect the landlord's perspective?
Well, I would have to say that the landlords have been fighting me tooth and nail for years. And so the landlords would seem to think that that the model lease is terribly onerous. But when you look at the additional terms that are required by the model lease, the name of the tenant, the name of the landlord, the address of the property, a few other details like that, including that the form of the lease shouldn't be something that's at issue, although it has been argued previously before this and other appellate courts. What's potentially of more concern, and I know that I'm raising a vulnerability that none of you have asked to speak about, is the criminal background check. But even that should not be of concern for landlords, because that's part of just the normal police powers. And so we're allowed to prevent discrimination based on the state statute. Our local police powers give us the right to be very careful about who is providing residential leaseholds for people. The city is allowed, and it has been recognized, to have a rental registry. That's another aspect of the second-class city code, which is not at issue in this case, but for an overall fair housing scheme to provide affordable housing for the tenants of the city of Pittsburgh. This is just one piece of it. Again, summing up, the state statute that prevents discrimination in the basis of housing is the express authority for the city of Pittsburgh. That statute has been interpreted to allow municipalities to identify classes that are subject to discrimination at the local level. The city of Pittsburgh has done so when it identified the people who hold housing choice vouchers, who are denied the option to use that entitlement because the local landlord community refuses to participate.
Thank you very much. Mr. Stang?
Yes, thank you, Your Honor. May it please the court. My name is Bill Stang. I represent the Apartment Association of Metropolitan Pittsburgh. I want to start off by saying that I think that a plain reading of the Commonwealth Court's March 2020 opinion shows that it correctly analyzed the second-class city code and the Pennsylvania Human Relations Act. I want to make one point about the Constitution that hasn't been made yet, and then 2 points about statutes that haven't really been made. Starting with the Constitution, here's what I think is important. Home rule authority starts with Article 9, Section 2 of the Constitution, and it's the Pennsylvania Constitution that makes home rule authority subject to the limitations provided by the legislature. And the business exclusion adopted by the legislature is directly aimed at limiting the power of home rule municipalities. And I think we all know what it states, and it's probably written 6 times in everybody's brief in this case, but I'll just paraphrase it and say that a municipality that adopts a home rule charter shall not determine responsibilities or requirements placed upon businesses, and here's the important part, except as expressly provided by statutes. So statutes applicable in every part of the Commonwealth. So here's where that takes us. What statutes are the city, or is the city relying on? Well, in their brief, they're relying on 2, the second-class city code and the Pennsylvania Human Relations Commission. I think we can dispense very quickly with the second-class city code for 2 reasons. First of all, It wasn't really relied on during oral argument today, but to the extent that there's any doubt about it, I noticed that the exact same section of the second-class city code was relied on by the city in the Pennsylvania restaurant case. And in that case, this court specifically looked at that. It's section 23-158 of the second-class city code. And with respect to that section, this court stated in Pennsylvania restaurant that it was a broad account of traditional police powers, but it wasn't enough to find express authorization for purposes of the business exclusion. That's in footnote 21 of the PA restaurant case. I hope that's all we have to say about the second-class city code, and I'll move on to the Pennsylvania Human Relations Act. Now, if you, again, getting back to Pennsylvania restaurant, if you compare the argument made for the Safe and Secure Building Act to the argument that is being made for the source of income ordinance, you get to the exact same result. In the for the source of income ordinance, to the extent they're relying on the Pennsylvania Human Relations Act, there are 4 sections that they cited. One section authorizes the city to create a local human relations commission. The other 3 sections discuss policy and talk about the procedures that the commission would have to follow. But what's important here, is in the Pennsylvania Human Relations Act, there is nothing that comes close to authorizing the city to impose business requirements on landlords. And there is nothing that indicates in any way that the legislature was permitting any municipality to force landlords to participate in a voluntary federal housing subsidy program. And the other thing, if you want to look at this from maybe a different perspective, there is nothing in the Pennsylvania Human Relations Act that shows the legislature intended to permit the city to negate rights that landlords have under the Landlord-Tenant Act. And the specific rights that I'm talking about, for example, would be the right as provided in the Landlord-Tenant Act to include a waiver of notice in a lease. Right now, that is permitted throughout the Commonwealth. That's part of the Landlord-Tenant Act. The exact section is quoted and cited in my brief. So I think that given that circumstance, plus the fact that there's nothing that the legislature said permitting any municipality to force landlords to participate in a voluntary federal program, then takes us back to the analysis that this court did in Pennsylvania Restaurant. And part of your analysis, of course, had to do with the Statutory Construction Act, and you talked about interpretation and interpretation of the phrase express authorization, and you indicated that express authorization, especially the word express, is based on common usage. And in addition, we have to pay attention to the fact that the General Assembly didn't intend results that are absurd. And I think it would be completely absurd if a city ordinance was permitted to negate the rights that the legislature has provided in the Landlord-Tenant Act. That would be a definition of absurd to permit this kind of inconsistency. So I don't know if anybody has any very specific questions, but I would like to add, before I answer any questions, that we're not saying that the city can't legislate against discrimination. What we're saying is that what the Commonwealth Court said, and what we believe this court has said in other cases, is that there is a significant difference between legislating against discrimination that is based on age, race, sex, and discrimination that is based on this source of income, the way the city does it. When you legislate against discrimination based on age, sex, or race, there are no business requirements or burdens being forced on landlords, and no rights are being taken away. So the business exclusion and the concept of express authority doesn't really come into play. On the other hand,
saying it's not just age, sex, and race. There are a number of things in the PHRA, national origin, religious creed, etc. Your point is, isn't it, that you can look through all those many things and source of income's nowhere there? Isn't that your point?
One of my points is that you can look through the entire list and there is no reference to source of income. And I think that's an important point, because if the city's going to rely on the PHRA, then they need to be able to point to where the Human Relations Act talks about source of income, and it doesn't. But the other
In fact,
I'm
Mr.
making,
Swank, it's Justice Todd, there's no reference to poverty, is there?
not in the Source of Income Act, there is not. No, I'm sorry. I'm sorry. Not in the Pennsylvania Human Relations Act. Correct. And the distinction I'm making, though, with source of income is that to prohibit discrimination against all of the items that Justice Wecht has referenced is completely different than preventing discrimination based on source of income, because when you bring source of income into the mix, now you are actually taking away landlords' rights and in other circumstances, forcing landlords to participate in programs that they don't necessarily want to be a part of. But that does not even come into play when you are prohibiting discrimination based on what I would consider the Pennsylvania Human Relations Act classes: age, sex, race, national origin, sexual orientation, things like that.
Counsel, it's Justice Donahue. Could a non-home rule charter municipality do what the city of Pittsburgh is attempting to do here?
Okay, I think that a non-home rule municipality could not do it either, but the reasoning would be a little bit different. For the non-home rule municipality, the argument would be that you simply cannot force a business to participate in an otherwise voluntary program.
Is that a takings argument? Is this confiscatory?
I don't know if I would. I just don't know if I would consider it a takings argument. I can see the logic, because the taking would be forcing someone to do something and expend resources on something that they on an act or a product that they otherwise wouldn't want to be a part of. But I also think that it's almost a basic freedom type of argument. And in addition to that, I would also like to add that I think that forcing landlords or any business owners to become participants in a voluntary federal program, such as the Housing Choice Voucher Program, is contrary, actually, to the I'll call it the procedures or the mandate of the program. Not only the courts, but also the housing the housing officials that run the program have said on many occasions that this is supposed to be a voluntary program.
Counsel, let me follow up on this distinction between home rule and non-home rule charter situations. Why would either the rationale or the outcome be any different between the two? Or should it be? The Commonwealth Court seems to imply that the result may be different if we were dealing with a non-home rule charter municipality. That would be contrary to what we talked about in the Pennsylvania Restaurants Association case, would it not?
Here's my point, if I could, about the Pennsylvania restaurant case. In that case, the city would like to argue in its second argument that the result of the Commonwealth Court decision that non-home rule municipalities improperly have more power or expanded powers that home rule municipalities don't have, but home rule municipalities are supposed to have more. That is not exactly what the Commonwealth Court said, and that is not what this Supreme Court has ever said. What this court has said and what the Commonwealth Court has said is that a home rule municipality can't have less power than a non-home rule municipality except where specified clearly by statute. And I think that phrase gets left out of the city's brief. It gets left out of the city's argument. This is what the Constitution mandates, and everything that we're talking about today, it actually flows from the Constitution. So
back to my original question then, would the result be different if we were dealing with a non-home rule charter municipality?
I don't believe that the result would be any different. I believe the arguments would certainly be different, but you are not, at the end of the day, I believe the result would be that you cannot force a business owner to participate in a voluntary program, governmental voluntary program.
Okay, thank you.
Mr. Stang, you want one sentence to complete your argument, or do we have it?
Very good. Okay. What I would say is if the city's interpretation of the exception to the business exclusion is correct, it would permit municipalities to negate statutory rights that are given to business owners by the legislature. For example, the right to include a waiver of notice in a lease. And it would force business owners, in this case residential landlords, to participate in voluntary federal programs. That, to me, is the definition of an absurd result, and that is not permitted by any of the statutes discussed today, as well as the Statutory Construction Act, which is a statute that we haven't really focused on during this hearing. Thank you.
Thank you very much. That'll complete our list. We will stand in recess for the day. For the justices, let's take 5 minutes, come back and vote. Okay, 5 minutes for us.